not to speak.
Will you tell us when you're set?
We're good.
All right.
You're set, Bob.
Very good. All right, our next speaker, I think we can all agree that this has been a tremendous way to begin the day. Our next speaker is Cyrus Amir-Mokri, who was born and raised in Tehran, Iran. He has been living in the United States since 1981. Attended Harvard University, graduated in 1986 with a degree in biochemistry. He then studied history at the University of Chicago, where he concentrated principally on diplomatic and on modern Middle Eastern history. A recipient of a Mellon Foundation Dissertation Year Fellowship, he authored a doctoral dissertation on Iranian constitutional history. Upon completing his doctoral studies, Mr. Amir-Mokri attended the University of Chicago Law School, from which he graduated in 1995. Since then, he has practiced law in Illinois and New York, and I think we have a couple of you from Illinois, and served as law clerk to the Honorable Bruce M. Salia of the United States Court of Appeals for the First Circuit. He currently resides in New York City, where he practices law and is a member of the law firm Skadden, Arps, Slate & Meagher from LLP. So I'd like to welcome our next guest. Thank you very much for joining us today, and we hope this will just be the first of many opportunities to hear you and to be associated with you and your group, because I know you're a member, right?
Yes.
Thank you.
Well, thank you very much for the kind introduction, and it's great to be here. As you know, I'm going to be talking about Iran's constitutional history. And just as a question, how many of you were aware that Iran had a written constitution in 1906? Okay, that's pretty good. That's pretty good. Often when I ask people, so what do you know about Iran and the rule of law and all that? And well, they say, Iran's a theocracy and it's governed by religious law. And to an extent today, obviously, that's all true. But Iran has actually had a relatively long history of constitutional government. And it started in 1906 with a constitutional revolution, or at least that's what it's called. But one of the realities about this, however, is, as you can see by the results today, is that what happened in 1906 didn't really end up with a constitutional government as we think about it generally today. So, in your common discourse with your colleagues, you would think about constitutional government in terms of, I guess the first thing that would come to mind would be, freedom of speech and personal liberties, and then democratic elections, popular participation. But Iran today has gone in a somewhat different direction. So one of the questions that comes up is, how can a country a century ago adopt, from all appearances, a Western-style constitution? And incidentally, the Iranian constitution was very much modeled on the Belgian constitution of 1835. So, this wasn't something that was dragged out of thin air. So how is it that a constitutional history like that, kind of changes course and ends up with what we see today? And since I'm going to break the suspense, since I've never been a fan of surprises, I'll kind of tell you where I'm headed with this, and then we'll walk through some of the specifics. Basically, the way I view it is that, yes, there was a constitution. It did signal the rule of law. But at the same time, the way the Constitution was structured in terms of the balance between the different branches of government and what the authority of each of these branches were was very imbalanced. And it was a recipe and formula for political crisis after political crisis. And once a constitution stops working and stops providing a framework for a practical resolution of problems and an inclusion of everyone in the process, then that's kind of a recipe for setting the stage for absolutism. And you can see this in many examples in history, and I think one of the most famous ones that's always referred to is the Weimar Constitution in Germany, which what happened during the interwar period. So what I've done is I think you should have a handout with you. I thought maybe an interesting way to do this would just to work through some of these principal points in the Constitution, so you can see both the affinity with Western political ideas that existed in this Constitution, how they were treated, but at the same time how they were different, and see why that can explain what happened in Iran over the course of the last century. And I think by going through this exercise, the other thing that I hope will happen is that it'll give you some perspective over some of the issues that exist today. As you know, in the Middle East, one of the big movements, and certainly a policy from this administration, has been to promote democracy. Promoting democracy and talking about it at an abstract level is a relatively simple thing to do. But as with everything else, the devil is in the details. And so you need to think about how you structure government and what kinds of consequences it's going to have. And so I think maybe this will help us at least identify some issues, even though I doubt that we'll come up with any bright solutions. Okay. I think the principal focus that I'm going to have is on the separation of powers. And let me just say a couple of general things. I'm sure you know a lot about the separation of powers, but I want to highlight a couple of features that come out very clearly in the writings of the founding fathers of the U.S., especially in the Federalist Papers, especially the writings of Hamilton and Madison. The first, you all know, checks and balances. That's the first thing you learn in civics. What does this mean, really? I like to think about these things in terms of concrete examples and everyday things that we hear about in the news all the time. And one of my favorites is the power of the veto. So as you know, Congress can pass a piece of legislation, and then the president can say, not signing this. And what usually happens is, the bill goes back, and either there has to be a supermajority or they have to do it a little differently to accommodate the president. Now, the veto is really a legislative function, effectively. But it's being wielded by the executive power. And this is what we mean by checks and balances in the framework of the American Constitution. That is, there are certain occasions provided for in the Constitution where one of the other branches of government has a partial function that's played by another branch. So this is, the president can't go in and say, okay, I'm going to redraft this portion, or I'm just going to authorize this by myself. But he does have the power to block it. And so that's a check, and that balances the two different branches of government. Another example is the power of appointments. Many appointments, even in the executive branch, have to be done by the advice and consent of the Senate. So there you have, that's essentially an executive function by the president. Ordinarily in any institution, you want to say, if I want to hire someone, I'm just going to hire them. No one else has, or the organization is going to hire them. Here, the organization wants to hire someone, but they need to get someone else's approval. And so that's kind of another example. Now, why don't we go to the Constitution itself? I wanted to start with the concept of, and let me add this point. What we're going to see, again, to take the suspense away, and what we're going to see with the Iranian Constitution is a fundamental imbalance in favor of the legislature. And so what does that mean as a practical matter? Essentially, I think two things. One is the reason why you have separation of powers. Think back to the writings of Montesquieu or whoever who theorized about this, was that you want to break up the functions of government so as to prevent absolutism or absolute rule from taking place. And so that's one rationale. But I think a second and equally important rationale, which you see a lot of in the Federalist Papers, is that government can function better, set aside the gridlock that you sometimes see, especially on this veto example, but government can function better if the specific functions are divided between people. And there's a very compelling argument to be had that a government that divides the functions and develops expertise in executing the laws, passing the laws, interpreting the laws, works a lot better and more efficiently than if someone had to do everything. And in fact, there is a growing line of thinking that says dictatorships in some senses bring a little bit of stability and order, but they're very inefficient, because if one person has to make every decision about everything, just think about the bottlenecks that would occur. So it's also a matter of efficient and effective government. But I mentioned it a few minutes ago that the Iranian constitution had a lot of Western elements in it, and I mentioned the Belgian constitution. Think about the first three words of the U.S. Constitution: "We the people." The concept of popular sovereignty, that is, it's the people's voice, that is the legitimate voice of government, was absolutely central to the Iranian constitution. If you turn to page 376 of this handout, actually 377. Look at Article 35, which, ironically enough, appears under the rights of the Persian throne. Article 35 says, "The sovereignty is a trust confided as a divine gift by the people to the person of the king." It's a little bit confusing, because on the one hand you have a reference to a divine gift, but at the same time you have this right being conferred by the people to the king. And this is the first time in Iranian history that this happens. In an official document, the people make an appearance as the legitimate fountain of authority of all political power. And that is obviously what the U.S. Constitution is based on. Now, this story about the divine gift is I'll just mention briefly, and this shows affinity between different political orders from what today you would call the Middle East to Western Europe. If you think back to even the English monarchy or the French monarchy in the Middle Ages, the idea was that the king's legitimacy came from God. And this is the same idea. It existed in Persian kingship as well, and it went back thousands of years. So, for many, many centuries, all political orders kind of had the same sense of what was the legitimate source of authority. It's only with the age of democratic revolutions that starts to change, and the people become the source of power, and that's what's reflected here. So you see this change in 1906 directly. Now, in terms of, let's go to the separation of powers quickly. So, the separation of powers, that concept never actually appears in the United States Constitution in those terms. There's no phrase saying there's a separation of powers. You can only imply that by the separateness of Article 1, 2, and 3, which deal with the legislature, Congress, the presidency, and then the judiciary. But in the Iranian Constitution, if you move back to Article 27 on page 376, it talks about the powers of the realm are divided into three categories. This is purely Montesquieu, right? And then you go to Article 28, and it says, "The three powers above mentioned shall ever remain distinct and separate from one another." So it's expressly enshrined. The notion of separation of powers that we think is such a great thing, expressly enshrined in the Iranian Constitution of 1906. Okay. But as I said, it's one thing to talk about something generally in the abstract. The other thing is that the devil is in the details. So let's take a look at the powers of the executive. And if you go to the next page, which is 378, I want to focus on Article 44 for the time being, but let me say one thing about the executive power. If you think to the American Constitution, Article 2 basically outlines the power of the president and his obligations. And one of the most important is that the president has the responsibility for faithfully executing the laws of the United States. And that is a very, very significant power. That basically means that once Congress passes the laws, it's up to the president to implement them. By the same token, what that does is if there's something wrong with implementing the laws, we know who's responsible, and next time when we go to elect a president, we can decide whether we're going to re-elect him or not. So you know where accountability is. All right, look at Article 44. The person of the king is exempted from responsibility. Okay, so right off the bat, you have no idea where the locus of accountability is going to be. We'll work through it, and then we'll see where it ends up. Now, part of this was, again, think back to what I said about this divine right of kings idea. One of the, and it's not necessarily in Hobbes, even though, but it's more kind of the medieval notion of kingship that I talked about, was that the monarch, because of his assumed relationship with God, was always considered to be innocent of any responsibility for anything bad that happened in the kingdom, because the king is innocent. God can't make a mistake, so it was always someone else's fault. The same concept in Iran. So that's why this gets put in the Constitution. So the person of the king is exempted from responsibility. But this has no, it's completely out of sync with modern notions of responsibility and accountability in the executive branch. Okay? So now, is there an independent executive branch? Let's find out. And you know the answer is no. Now, if you go to the next article, Article 45, this is the start of it. Okay? It says, the decrees and rescripts of the king relating to the affairs of state can only be carried out when they're countersigned by the responsible minister, who is also responsible for the authenticity of such decree or rescript. So basically, the king can write whatever he wants. It's not going to get done unless a minister countersigns it. Okay? So that's point one. So now, not only is the king not responsible, but anything he says is not necessarily effective when he says it. Let's go back to the American Constitution again. One of the ideas that is central to the U.S. Constitution is that you have one executive. During the Constitutional Convention, there was some debate about whether we should have 2 executives or 3 executives. Think about the Roman Empire and the triumvirates and the diumvirates and all that. And everyone said, no, in order to be most effective, you need, to quote Harry Truman, the buck needs to stop somewhere. And that's with one person. And so that's the concept of the U.S. Constitution. Right here, you automatically have, the king can say something, but, the minister's not going to, he's not going to countersign it. So what's the king going to do? We'll get to that in a minute. But you can already see the seeds of kind of disorder in government. Okay? So, what's the king going to do? Ordinarily, if you have insubordination, think about any institution that you work in. If someone's not doing their job, you want to be able to fire them, right? All right, let's see if the king can fire anyone. The answer is suggested but not answered by Article 46 here. It says the appointment and dismissal of ministers is effected by virtue of the royal decree of the king. Well, the previous, you already see a problem, because who gets to countersign this, right? Well, that's one problem. There's another problem, too. But let me again go back to the U.S. Constitution. There was a very important case in the 1920s decided by the Supreme Court where the question was, who has the power of removal for someone in the executive branch, who's purely in the executive branch? And the Supreme Court said, yes, we realize that the Constitution has some provisions where appointments, there's kind of this checks and balances thing. But removal, if someone's being insubordinate and the president needs to remove them, government's just not going to be effective if he can't fire them. So the power of removal is going to fall within the powers of Article 2. And that's going to rest with the president. Okay? Well, here you already see that, well, that may not really be the case. And so why don't we turn the page and go to Article 67. This is on page 380. Now, Article 67 says, if the National Consultative Assembly or the Senate shall, by an absolute majority like 51%, I can't think of anything else, declare itself dissatisfied with the cabinet or with one particular minister, that cabinet or minister shall resign their or his ministerial functions. The word shall, incidentally, this translation, a note on the translation, was made by a really prominent and fantastic scholar of Iran, a gentleman named Edward Brown, who taught at Cambridge University for many years, and he, perhaps more than anyone else, was responsible, I believe, for introducing Iranian literature, Iranian history, and contemporary events of that time, of the turn of the century, to the English-speaking public. And I've checked the translation against the original. It's a pretty good translation. So he says, they shall resign their ministerial functions. Again, think about the removal power under Article 2 of the U.S. Constitution. Here, the king can put out a decree. It sounds like it needs to be countersigned by the minister to begin with, but even more than that, if the king likes the cabinet and the way they're functioning and the way they're executing the laws, Parliament may decide, no, we don't like him, and let's fire him. I mean, just think about what would happen if Congress decided that tomorrow they're going to fire Secretary Rice, or anything like that. I mean, it's really remarkable when you think about the way they've set this up and how it translates into the everyday functioning of government. Now, let's step back. What was going on? There's a lot of political history going on here. This Constitution was put together in the face of a lot of opposition from the monarchy. The king didn't want to give up his absolute power, and here you have these revolutionaries saying, okay, we're going to take it away from him, and we're going to take it away from him forever, right? And so this is what ends up happening. But that kind of emotion and that kind of setting up of government and taking away power from someone thinking about the issue in terms of the politics of those days is not a formula for building a structure of government that's going to last over a period of years. And you can see this very clearly in this text that I would submit to you. So, not only can they remove the ministers, if you look at Articles 65 and 66, they can do more. 65. The National Consultative Assembly or the Senate can call ministers to account or bring them to trial. And who passes the law to determine whether they're going to be brought to account or taken to trial? Well, Parliament, of course. The law shall determine the responsibility of ministers and the punishments to which they are liable. In the American Constitution, it's very different. Removal of executive branch officers, it's on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. And as you know, America's history with that has also been difficult. Usually it has, remember the Watergate era where it had to start with the Attorney General, and then because of that experience we came up with the Independent Counsel statute, and saw what happened with that. It's a very difficult issue, you know. But the way the Iranian constitution decided to deal with this was say Parliament's going to have it. So I think that kind of gives you a sense of the imbalance between the legislature and the executive branch. Now let's take a quick look at the legislature and the judiciary.
Can I ask a quick question?
Absolutely.
Number 66 says the law shall determine the responsibility of ministers
Yes.
and the punishment to which they are liable.
Yes.
Which law?
That's the law passed by Parliament.
Oh.
Yeah. But that's a good question. And to take the suspense away, we'll see that a lot of the structure of government and law that we are seeing in Iran today has its origin in this document, and we'll get to that at the end. That's what I'm going to build to. I mean, you'll see that the legislature was all powerful in this, and within the legislature there was a certain group that controlled it, and we'll get to that. So why don't we go to, as I said, the judiciary. Now, you're familiar with American constitutional history. Even if you're just very minimally familiar with it, you must have heard of the case of Marbury versus Madison, where the Supreme Court said that basically the judiciary is the ultimate voice for interpreting the Constitution and what the laws are. And so they, obviously the Supreme Court has the last word on the Constitution. It also gives authoritative interpretations of statutory law. If Congress disagrees with that interpretation, they can obviously go back and redo the law. But the judiciary gets to interpret it, and there's no discussion about that. So now, let's take a look and see what the Iranian Constitution says about that. Why don't we go to Article 27 on page 376. We saw this provision before when we were talking about the separation of powers. And in the structure of the Constitution, what they're doing here is, as they introduce each power, they kind of have a synopsis of what they do and what their authority is. Okay? So look at first. Well, actually, let's skip the second just to give it perspective. It talks about the judicial power, by which it's meant the determining of rights. And then the next sentence says, this power belongs exclusively to the ecclesiastical tribunals in matters connected with the ecclesiastical law, and to the civil tribunals in the matters connected with ordinary law, and that would be law that's passed by Parliament. But it doesn't really say anything more than that. The key sentence is the sentence above that, which is contained in the legislative powers. I'm sorry, the last sentence of the previous paragraph. After talking about the laws passed by Parliament, it says, in the entirety of that paragraph, the explanation and interpretation of these laws are, moreover, amongst the special functions of the above-mentioned assembly. So they pass the laws, and then they'll tell you what it means. It's an incredible grant of power to the National Assembly. And again, put it in political context. The judges before were kind of the monarch's henchmen, and this was the means by which the revolutionaries could say, okay, we're going to keep that power with the people, because their assumption was, the people's representatives are going to get elected, they're going to be good folks, they're going to know what to do, they're going to know what the people want, and so they're the best check against absolutism, and that's exactly what they put. The other lesson I want to impart here is that these sentences were not put together accidentally. And one of the misperceptions is that, the Iranians just picked up the Belgian constitution and 5 guys just translated it into Persian the best they could, and, that was that. No, I mean, and as you're about to see, they sat down and they thought about these things, and they changed the Belgian constitution in material ways to suit the political purposes of that day. But what they weren't thinking about was, what's this going to be, or how's this going to work in the long run? Now, there is incidentally, judicial appointments, unclear. There isn't really much that says in the Constitution about how judicial appointments work. So let me, I think I've tried to make a case so far for Parliament, or the legislature, kind of being the dominant branch of government under this Constitution. Very unlike the U.S. Constitution. Even though it talks about separation of powers, the notion of checks and balances and all that is really non-existent. So you can talk about democracy, separation of powers, and human rights and all that you want, but it really matters how you set it up, and it really matters what kind of commitment people have to making something work. And so, so you see that there are fundamental issues here. But there's another big issue, and here is, I think, one of the most interesting aspects of this whole Constitution, and this is the legacy that you see today. Remember, we started the conversation with this notion of popular sovereignty, and then there was this divine gift and all that. Why don't we go to Article 2? That's on page 372 of the handout. Incidentally, but before we get to Article 2, actually a nice introduction to that is Article 1. And think about the Bill of Rights and the Establishment Clause, where basically the Constitution forbids the establishment of a religion. And again, students of American political history will know exactly why. The facts in Iran were very different. Iran was talk about vast majority, 95+% Shiite Muslim. And not just any Shia Muslim. For example, the Ismailis are Shia. There are other branches of Shia, who believe that the Prophet's son-in-law, Ali, is the legitimate heir to legitimacy in Islam. This is the Jafari sect, which is different from the Ismailis. At some point, the descendants branch off. This is a very, very specific branch of Shia Islam, which obviously the adherents are not only in Iran, but in a large part of Iraq today. Sistani and others are all adherents to this particular faith. So it says the official religion of Persia is Islam according to the Orthodox Jafari doctrine, which faith the Shah of Persia must profess and promote. So it's not just that he has to believe in it; he has to promote it. And what does promotion mean? It could mean anything. Forced conversions would. That's been the realities. It was the reality in the 19th century, and even parts of the 20th century. We had some experiences with that. I mean, the Muhammad Reza Shah Pahlavi was also not immune to the force of this thinking. Now, with that in mind, go to Article 2, which I think is one of the more remarkable provisions of this Constitution. Think about the legislature. It's the dominant branch of government. And whenever you have a situation like that, and you had this question asked about absolute monarchs as well, so who watches over them? With the absolute monarchs, the question was, the answer usually was, well, in the afterworld, they have to respond to God, so that's really the check. Well, here the check is Article 2. And I will, so if you look at the second paragraph, it says, "It is hereby declared," this is on page 373, "that it is for the learned doctors of theology, the ulama, may God prolong the blessing of their existence, to determine whether such laws as may be proposed," this is to the Parliament, "are or are not conformable to the principles of Islam." So they are the ones who, at the end of the day, decide whether a piece of legislation can even be enacted. I mean, it has to go through the to that check. Therefore, just continuing, it is officially enacted that there shall at all times exist a committee composed of not less than 5 mujtahids or other devout theologians, cognizant also of the requirements of the age in this manner. So now, not only do you have the concept of, who's going to watch over this legislation, you have a body, a committee of 5. Incidentally, this was really honored in the breach, as I'm about to explain in a minute. But the fact is that even under the Shah, this provision was never altered, and I'll get to that concept in a minute. There was an important reason for that. Now, how are these folks to be elected? You would think, a document that says the right of sovereignty rests with the people and they confer it on the king, that they'll have something to say about this. Nope. The next sentence. "The ulama and proofs of Islam shall present to the National Consultative Assembly the names of 20 of the ulama possessing the attributes mentioned above. And the members of the National Consultative Assembly shall, either by unanimous acclamation or by vote, designate 5 or more of these according to the exigencies of the time and recognize these as members." Now, yes, you can make an argument that Parliament gets to vote and Parliament's been elected by the people, but that's not really the answer, because who's made a candidate in the first place? It's the people who are selected by the ulama, or the mujtahid. So, the pool of candidates has already been predetermined, and they have to pick one of those, or 5 of those folks. And that again takes, is a formula for taking popular sovereignty out of the equation. Now, the next sentence. What are the powers? What can these folks do? They, just continue on. So they may carefully discuss and consider all matters proposed in the Assembly and reject and repudiate, wholly or in part, any such proposal which is at variance with the sacred laws of Islam, so that it shall not obtain the title of legality. It then follows, "In such matters, the decision of this ecclesiastical committee shall be followed and obeyed." No discretion. Parliament can't say anything. So, the candidates are chosen by the clerics. Parliament has to vote 5 of them in, and they have to listen to them. There's no discretion whatsoever. And now, why wasn't this changed? This is another remarkable thing. "And this article," this is the last phrase, "shall continue unchanged until the appearance of His Holiness the Proof of the Age." This is the 12th Imam who is going to appear. Think about the American Constitution. If there's a provision of the Constitution that needs to be changed or something needs to be added, Article 5 has the amendment provision. The people can come in and amend the Constitution. This Constitution can also be amended, everything except for this article. So the framers of this Constitution at least thought that this was something that should not be changed. And so we started with the proposition of popular sovereignty, And now, basically, we see that not only is, there are a lot of contradictions in here, that there is a provision that completely undermines the notion of popular sovereignty, but it can never be changed. The same idea, when you think about the Constitution of the Islamic Republic, you know how familiar you are with the structure of government there, but it's again, a very complicated structure just from a practical point of view. Think about the executive branch. You have a president. You used to have a prime minister. They excised that. That wasn't workable because the president and prime minister were fighting all the time. This was in the early 80s, so the Islamic Republic amended the Constitution to at least get rid of that. But you have the supreme leader who has the powers to, say anything, and he is the final word. So, what good is a president? I mean, think in terms of separation of powers, of appointing people, of removing people, of, if he doesn't have final say, and it's really the supreme leader, you can think about, just think about it in practical terms. How do you conduct diplomacy with a government like that? To whom do you speak? Whose word matters? How does anything get done? Does anything get done? And the answers to a lot of kind of common problems that you see actually can be detected in the way a constitutional structure is set up. The other thing it tells you is that as absolutist or arbitrary as a government may seem, don't take things like constitutions and written sources of law for naught. They actually do have an impact, and people actually refer back to them to try to work their way through the system by using these documents, because it gives a measure of certainty. But if the document itself does not afford the kind of certainty and predictability in managing government, then you kind of have the results that you see. You have no idea who's in charge, and you don't know whose word matters. Everyone's word matters at a certain level, but those are the kinds of dilemmas that you're faced with. And also, the other thing that you can see is the idea of government checked by religious law was not plucked out of thin air in 1979 when these folks sat down to write the Constitution. I remember I was in Iran at that time, and I was following very carefully the Constituent Assembly. And in fact, it was broadcast on TV, and I would, I was like 14 or 15 years old at the time, and I would sit and with great interest watch the debates. I can't say that I understood everything that they said, but they were very entertaining in how they said it. And but I do remember the biggest debate at that time was, should we put in Article 5, which is the rule of the jurisprudent, this supreme leader provision. And there were a lot of people who were opposed to it because they made the same arguments that you see in this document, which is, the people have to rule, and if you have someone who comes in and can just overturn everything that the people want to do, that's not democracy. We fought for democracy. We fought for popular government. But this shows that at least those who are advocating that kind of government, and this so-called Council of Guardians that you have, that's an adjunct to Parliament in Iran nowadays, where it's a body that essentially has the power to negate or undo any legislation that even that Parliament passes. A Parliament, incidentally, whose nominees or the candidates for Parliament already have to be vetted by that same body. So again, nothing new. It's all in here. So you see that none of those notions